Understanding the legal foundation of property management. Before we can manage property correctly, we must first understand how Arizona law defines it. ARS, paragraph 32 to 2171, provides the foundational definitions that shape everything we do in property management. A property management firm is defined as a corporation, partnership, limited liability company, or designated broker that manages rental property for compensation under a written agreement. A rental agreement is defined as a lease or leasing agreement. This definition is simple but extremely important. The moment you manage property for compensation, you are operating under Arizona property management laws. This triggers licensing requirements, supervision obligations, trust account rules, and audit exposure. Think of it this way: if money is involved, regulation is involved. Who can legally operate a property management firm? Under ARS paragraph 32, 2125, entities such as corporations, LLCs, and partnerships must designate a licensed broker to act as the designated broker. This individual must also be tied to the entity in a leadership role, such as an officer, manager, or partner. No other individual may act as the designated broker for that entity. For example, a group of investors forms an LLC in Phoenix to manage rental properties. One member holds a real estate license but is not named as the designated broker. Even if that individual is highly experienced, they cannot legally perform broker-level activities for that entity unless they are officially designated. This is one of the most common compliance issues seen in audits. Assuming a license alone is enough without proper designation. The key takeaway is clear. The designated broker is the legal authority responsible for the operation. Core responsibilities of property management in practice. Once a property management firm is properly established, the real work begins. Property management is not a single task. It is a system of responsibilities that must all function together. Leasing and tenant management involves marketing vacant units, screening tenants, preparing lease agreements, handling renewals, enforcing lease terms, and addressing tenant complaints. For example, if a property manager skips proper tenant screening in Mesa and places a high-risk tenant, that single decision can lead to property damage, eviction costs, and potential liability for the broker. Rent collection and financial management includes collecting rents, handling deposits, tracking income and expenses, preparing budgets, and providing financial reports to owners. This is directly tied to Arizona trust account laws under ARS, paragraph 32 to 174. Even small accounting errors can become major violations if not handled correctly. Maintenance and repairs include inspections, coordinating repairs, managing vendors, and responding to emergency issues. Imagine a scenario in Tucson where a water leak is reported and ignored. What starts as a maintenance issue can quickly become a habitability violation and legal problem under landlord-tenant law. Property marketing and advertising must comply with AAC R4 28502, ensuring that all advertising is truthful and properly identifies the brokerage. Legal compliance ties everything together. This includes fair housing laws, landlord-tenant regulations, safety requirements, and privacy protections. Community management adds additional responsibilities such as managing HOA budgets, enforcing rules, and maintaining common areas. Risk management includes evaluating potential liabilities and ensuring proper insurance coverage is in place. Each of these responsibilities is interconnected. When one fails, it often impacts several others. Fair housing, where fiduciary duty stops. One of the most important legal concepts in property management is understanding that fiduciary duty does not override the law. Consider this scenario. A property owner instructs a broker to only rent to families. The broker explains that this could violate the Fair Housing Act, but the owner insists and claims the broker must follow their instructions. The broker is not required to comply. Fair housing laws prohibit discrimination based on protected classes, including familial status. A broker cannot carry out instructions that would violate federal or state law, even under a duty of obedience. If the owner refuses to comply, the broker may terminate the property management relationship. This principle aligns with Arizona case law such as Jennings v. Lee, which reinforces that fiduciary duties must always operate within legal boundaries. The takeaway is simple: you cannot follow illegal instructions, even from your client. E&O insurance, protection with limits, errors and omissions. E&O insurance is a key part of risk management in property management. It provides protection against claims of negligence, mistakes, or failure to perform professional duties. For example, if a property manager improperly handles a lease or fails to document a tenant issue correctly, and the owner suffers financial loss, E&O insurance may help cover legal costs and potential settlements. It can also provide protection in cases involving tenant placement errors, contract disputes, or eviction mistakes. However, there are important limitations. E&O insurance generally does not cover intentional wrongdoing, criminal acts, or fraudulent behavior. For instance, if a broker knowingly violates fair housing laws or intentionally misuses trust funds, that claim would likely be denied. E&O insurance is a safety net, not a substitute for proper procedures and compliance. The role of ADRI in property management oversight. The Arizona Department of Real Estate, ADRA, regulates property management to ensure brokers operate ethically and in compliance with state law. ADRA enforces licensing requirements under ARS, paragraph 32, 2125, trust account handling under ARS, paragraph 32, 2174, and record-keeping requirements under ARS, paragraph 32, 2175. They also enforce advertising rules under AAC, R4, 28, 502. In addition, ADRI conducts audits and investigates complaints from tenants, owners, and the public. A common misconception is that audits only happen when something goes wrong. In reality, audits can occur randomly or as part of routine oversight. The brokers who succeed long-term are the ones who operate as if an audit could happen at any time. How this section connects forward. This section establishes the legal definitions and operational responsibilities that form the foundation of property management. As we move into the next section, we will take this foundation and apply it directly to broker supervision and control, where these responsibilities become enforceable duties under Arizona law. Online discussion. Why is the designation of a broker required for an entity operating a property management business? Answer: because Arizona law requires a designated broker to be responsible for supervision, compliance, and all brokerage activities conducted by the entity. Can a broker follow a client's instruction if it violates fair housing laws? Explain why. Answer: no, because fiduciary duties do not override legal obligations, and brokers must refuse to participate in discriminatory or illegal practices. Why is E&O insurance important, and what is its biggest limitation? Answer: it is important because it protects against claims of negligence and mistakes, but its biggest limitation is that it does not cover intentional wrongdoing or illegal acts.